Hi, everyone. We're going to go ahead and get started. I think a few more people trickling in, but that's okay. Thank you for coming today to our next installment of the Harris County Law Library's Legal Tech Institute. We offer a wide range of programs on legal tech topics, and you can find out more about that at harriscountylawlibrary.org/tech. Today's topic is one that has received a lot of attention recently. Cloud computing has become ubiquitous for all types of work, and so naturally lawyers are using it more and more. We're very happy to have someone who I would call an expert on the subject, Sammy Ford IV. He's an attorney with AZA Law here in Houston. He's a graduate of Harvard College and University of Texas School of Law, both with honors, and he also presents regularly for the HBA and also the State Bar of Texas on legal tech topics, including cloud computing. So we're very happy to have him here today. Without further ado, I will go ahead and hand it over to Sammy.
Great, thank you. So today's topic is the ethical considerations involved in using cloud services and cloud computing. And it's right, it has gotten a lot of interest over the years, especially recently with some of the hacks and other news items that have happened. And as we go through the presentation, we'll see where some of those more recent news stories kind of impact our practice or the practice of law. But first of all, I wanted to start with this. I kind of like this. The cloud is merely a fancy way of saying stuff's not on your own computer. And that's the formal opinion from the Pennsylvania Bar Association. And I think this is a really, really good way to get over some of the initial fear involved in sort of what is this cloud computing thing? What is this? What are the ethics of it? Because when you can sort of put it in just incredibly basic terms of it's giving your or your client's data to someone else, I think that starts your thought process as a lawyer very early on in terms of what it is you can and can't do and what you should consider before you allow someone else to take yours or your client's data from you. So what we're going to go through today is a little bit of like the history of cloud computing, some of the legal and ethical opinions that have been issued by various states and bar associations, ethical concerns with data privacy, some cloud computing options, though a little bit less. And then if there are any questions, I will take them and end with some suggested questions to ask yourself when you are considering using any of these cloud computing options. So the short of it is, the cloud is becoming ever more important because it changes the way that we work. It changes where we can work, what we have access to when we are working, what types of applications we are using, and even how we communicate with our clients now. So you kind of like the prehistory of work in a law firm, though not really the prehistory because I'm starting with email and file services, but I guess just indulge me that. And so we'll start with, this is essentially a system, and there are some law firms that I am aware of that still operate largely in this way. They do not allow remote access to their email, to any file folders or servers. Though they do have internet, they do not allow someone outside of the firm access to that. And so this is a pretty traditional closed network model. The only thing you would change here would be showing that you can access the internet from any of these people, the attorney, the paralegal, legal assistant, etc. But with this way, your data is stored on your equipment, and your client's data is stored on your equipment. What's interesting, though, is that even though this is the historical model for using information technology, it's not really the historical model for any other type of client data or even attorney data. And just to go back, and the reason for that is when you consider that most of our copying or most copying is done outside of law firms, you use other companies for process serving, obviously you use other companies for the delivery of documents. More often than not, you are not going to handle your client's data from the moment your client gives it to you to the moment you return it to your client. Someone else is going to touch it at some point. And that, I think, again, gets us into sort of where the cloud is important because it's very analogous to that. So another, model of work would allow sort of just moving from the entirely in-office storage of the information to without external access, to allowing external access but still storing your emails and your documents, et cetera, on documents within the office, whether that's a law firm or elsewhere. And this is a pretty, still a pretty common approach to how to store data. At least this is the officially common approach to store data. And the reason I say that is because I think that the introduction of cloud storage systems has totally changed just how that works, in the sense that you may store all of your files, or you may have a policy to store your files on an in-house server that can be accessed in the way that we just saw. But I guarantee you now, when someone wants to work on a file remotely, or they want to take it with them on an airplane or something along those lines, they're more likely to store it on a cloud file server. And that cloud file server, from the perspective of the user, may just be a folder, or would just be a folder on their computer. So from the user's perspective, they're not really changing anything, but where that data resides, where it sits, is fundamentally different. Which is why I think that the second view is a little bit more holistic, because it recognizes that your client, you or your paralegal or legal assistant or the receptionist or anyone else who practices will be using various cloud services all the time. And it's not an exception, it's almost the rule. Now, so we talked about what the cloud is, but these characteristics, I think, are very, very important for why it is so popular, but at the same time why we need to understand it. When you have a in-house server, you're limited by the capacity of that server as you get it from your vendor. And you can expand it, you can increase the memory, the hard drive space, you can upgrade your programs, et cetera, but you are always limited to what you have at that point. The benefit to the cloud is that because you're using someone else's storage system, someone else's computing power, and in a lot of cases probably Amazon's, it's very elastic. If you need 1 terabyte of data to store a giant set of documents that your client sent to you, you can do that. If you have 500 megs, you can do that. And you're really only paying for what it is that you're using. And also the network access. That sort of cuts both ways. But the truth is, if we don't have our cell phones or internet access at the office, how many of us think that we can really be productive? I mean, I just usually go home at those times. It's like losing the water. It's a resource that we need. And so this is primarily for people, in private practice, but still the reason for using the cloud, especially for law firms, is that you have individuals and companies that their whole job is providing these services. your office is much less secure, regardless of where you are, what it is, than the storage sites and facilities offered by reputable cloud vendors. Just to give you an example, when we had, I think it was the tax day floods of 2014 or 15, I believe, and a firm where I was working at the time, because a lot of the data was stored at the office, when the building lost its power and we couldn't bring it online, it meant that you couldn't go to the building to get your documents because it didn't matter if you're sitting at your desk or sitting at home. But more importantly, it sort of made clear that making the data or putting the data somewhere other than the office made a lot of sense, even if it was just a backup or a secondary, like a fallback option, it was a mirror, whatever. Because again, a server in an office is less secure on average than a server at Amazon or Google or Apple's warehouse. And when I say secure, I mean primarily physically secure. There can be some security issues beyond the physical, but also the cost savings are important. And that's, I mean, kind of, so the other way to approach this, though, is that not using the cloud at this point is almost like refusing to use wills. It's just the future. There's not going to be a future in which you're not using the cloud in some way, shape, or form. By virtue of using your cell phone every day, you are using the cloud in some capacity. So a couple of the attacks on law firms. Law firms are a very, very rich target for hackers, and lawyers are very, very rich targets for hackers. And I mean, if you had to think about it, what other group of people short of your financial planner have as much information about you other than your attorneys? With respect to your medical records, maybe your doctor. But at the time you have a personal injury suit, your lawyer is going to have a lot of those records, and maybe even more than any individual physician does. And likewise with large multinational firms with 4,000, 5,000 lawyers and 5,000 administrative staff, etc. I mean, if you want to know what is going on at any business, that's probably the best way or the easiest way to find that out, to improperly find that out, because I can guarantee you companies like large oil and gas companies, accounting firms to some degree, but other companies have very, very strict security in terms of how they use their IT equipment. I mean, you have to insert personal cards into the computers before they get turned on. They have policies of not allowing you to leave your computer in your car when you're not in it. You can leave it in a hotel room or your house. That's pretty much the only places you can leave it are where you would sleep. So the weak link often are law firms, and with respect to using the cloud, I think that will only continue. Another reason is just from a purely practical standpoint, most of our assets are now intangible. It was the case that for most people, and this is probably true to some degree for a lot of individuals, a lot of their assets are tangible in the sense of homes and cars, but with respect to businesses, those assets become more and more intangible. So what do the rules say? The Texas rules are, well, they're right here. I mean, this is, to the extent that they are talking about how you use the cloud, it is that you have to have, or you have an obligation to have confidence in the performance of your duties. You also have an obligation to protect the confidential information of your client, the information and the property. And so this is sort of our baseline for how to analyze what it is that you do with the cloud. Because remember, again, the cloud is just a fancy way of saying somebody else has your data or your client's data. And if you're going to give someone else your client's data or your data as a part of the practice, your practice, then you have to have competence in that. So the ABA model rules of professional conduct speak a little bit more clearly to the issues about the impact of not just the cloud, but computing in general. And so this is, comment 8 was added in 2012 to the model rules. And it says, to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in law and its practice, including the benefits and risks associated with relevant technology, and engage in continuing study and education. So the short of it is that I think that as we go forward, some form of tech education, if not a formal component of our CLE requirements, will be so prevalent that even if Texas were to adopt Comment 8 or Rule 1.1 of the Texas or of the ABA Model Rules of Professional Conduct, I think that that's where we're going by virtue of participating in this sort of CLE. You're already there, but I think the CLE requirements are only getting more and more onerous. As we know, that the State Bar recently removed the exemption for attorneys over, I believe, the age of 70. And I think in light of what we're talking about, this becomes more and more important. So this is Rule 1.6 of the ABA's model rules. And what was interesting is the comment that, again, was added in 2012. And it's a little bit, it's long, and this isn't the entirety of it. But the short of it, which I think is kind of like a safe harbor in terms of how you protect your client's information, and it is that the disclosure of information is not a violation of the rules of professional conduct if it's inadvertent and you use reasonable efforts to prevent the access to the information or the disclosure. And the factors to be considered are the sensitivity of the information, the extent to which the safeguards adversely affect the lawyer's ability to represent clients, and also to the extent to which what it is that you did is in keeping with the practice of other lawyers or just generally accepted generally accepted confidentiality approaches. But what's particularly interesting to me about this, and we'll see it in relation to Texas shortly, is that whether you're required to take additional steps under the rules the rule is not it. You also have to look at state and federal law as to what it means to protect your client's information. And that includes how to protect your client's electronic information. And the most obvious one is HIPAA, which applies to lawyers now, which we'll see. So as the ABA laid out the issues that it saw with respect to what existed or exists with the cloud, the number one is the unauthorized access. And because as you allow more and more points of entry into data, it seems more likely than not that someone else may have access to it. And the simplest way to think about that is with your cell phones. If you don't have a password on your cell phone, you can log in and access a lot of your information. Now, some apps will require additional logins, but one of the safest ways to protect your phone is by using, with iPhones and with Androids as they exist, is using the fingerprint recognition. But what's interesting about that, again, is that oftentimes when you set up your logins, like if you set up your bank login or you set up some other login, they'll ask you with the iPhone, do you want to use Touch ID to log in with to this as well. Well, anyone who can access your phone using Touch ID can access any app or program that you allow to be accessed through Touch ID. Like I said, it's still a very safe way of protecting, but it's something to keep in mind. A couple ethics opinions that have been issued. So Arizona was one of the first. It came out in 2005. Florida had one from 2010. So we're already, 7 years or so later, and they were speaking about, if you use electronic storage of some sort, you have to ensure that that storage maintains your client's confidentiality. Likewise, Alabama came out with an opinion around the same time, allowing lawyers in Alabama to use cloud computing. Oregon. So when this was 2011, no state, you can go through, I'm happy to give you this presentation so you can read these ethics opinions. Ohio is one of the most recent states to issue an ethics opinion, and it dates from 2013. In fact, I think there may have been one from 2014, but 2013 was one of the latest opinions. And again, it just said that the storing client information in the cloud is just a permutation of the way lawyers have always done things. And so whatever ethical rules you followed before, you have to continue to follow, modified to the extent that the cloud modifies how that information is given or stored. Texas still does not have any opinion on the use of cloud computing or sort of technical competence, etc. And I think that this is probably a good thing. Not in the sense I think that ethics opinions are bad things. It's just that I think that we have a pretty solid consensus from other states and from the ABA in terms of the allowability of using the cloud. That's not in question anymore. And so I'm not entirely sure that we are ready, based on my research and based on what other opinions have come out, ready for more detailed guidance at this point, because I think that some of the other issues that have come up, some of the other suggestions are not quite ready for prime time. And we'll talk about some of those in a moment. So, but obviously Texas has, opinions on some of the same issues with respect to how other states have reasoned and analogized to whether you can use cloud computing. And so now you can give information to third parties for copying services, and you probably don't need your client's opinion or your client's permission to do so. Which was one thing that the model rules in the comment 8 did discuss. The client can say no, and that's still true. It's whether you need permission beforehand. The client can say no, but it may also be because the nature of the data is such that it shouldn't be stored on a cloud service. We haven't made it at that point in Texas. At least in my practice and in my reading, I'm not aware of any documents that would be given to a client or to a lawyer from a client that the lawyer couldn't use a copy service to make duplicates of. I'm not saying they don't exist, I just have not come across that. I haven't seen it discussed. However, I do know some only allow, when you're looking at review platforms for their data, for production, will only allow you to use either an in-house solution, so where the data is stored on your servers, or they will require you to use a vendor that they have a contract with. And in part that may have something to do with cost, but I think largely it has to do with limiting the universe of where their data is stored in its raw form before it's reviewed and produced, et cetera. Either it's going to be with you, lawyer, that I have an attorney-client relationship with, or it's going to be with someone that I have spent time vetting. That's the only sort of situation that I can think of that would provide a little bit of a wrinkle, at least in Texas, between using off-site document production or off-site copy services and cloud services. So I was looking, and this was, I first gave this presentation in 2012, and at the time, the Snowden leak from the NSA was very much in the news. And, so I kept this slide in, but what's interesting to me is that since Snowden, we've had so many other sort of hacks and data breaches that specifically have to do with the cloud, which is why I think that we should spend a little bit of time on this. The most recent, so the 2016 election, kind of highlighted to some degree this issue, and in part this is just a password issue, right? Because that's how the hackers were able to gain access to the emails that were stored in someone's Gmail account by using a phishing technique, having them click on a link that stole passwords, etc. But I think that considering what else is stored on some of these services should, and this is why I think this is very important for lawyers, and why it's different than just an ordinary breach of a, when you hear about Target being breached or Yahoo being, well, Yahoo's a great example actually, but so Target being breached or whatever, because when they are able to get into your Gmail account or into your Yahoo account, and you also use Yahoo and Gmail to store files, to keep your calendar, to keep client information, you have to be very, very careful. If all it takes for you to see it is to log in to some service, if they are able to find a way into that service using your credentials in any way, shape, or form, your entire, everything that you've stored is out in the open. The CIA hack, which was one of the more recent releases from WikiLeaks, same thing in the sense that this was what I found kind of interesting about it when I read more and more about it was that first of all, the majority of the attacks that were disclosed and claimed to be used, a lot of them were old. In fact, most of them were old, and the majority of them probably no longer represent active threats to individuals or to us or our computers or TVs or anything. But the way that the CIA was able to get that entry into individuals' phones and computers is just through exploits that are known throughout hacking circles. It wasn't like these are things that were placed in there by and large by companies and given to the CIA. This was the CIA was using, just going on the internet and speaking to other hackers about getting access to these devices. There were some disclosures of the CIA actually paying for, like some of these exploits, but a lot of them were just publicly available exploits. And it included everything where data is stored or can be stored. So we often don't think about it. And one that I didn't see referenced in any report, but one that should be of particular concern to lawyers is if you have like any form of network attached printer, when you send documents to that printer, when you're scanning documents to that printer has a hard drive. It's storing that information. It may store that information on another server. That server may be backed up to the cloud, whatever. The point is, there are many, many different ways into a law firm for getting client information. But what is most important, though, is that I think that in some ways the revelation is not nearly as big as we originally thought. And the reason is that what they have found is that nothing from this particular document dump. Now, this is not to claim that any particular type of encryption is perfect or foolproof. Probably not. With a strong enough computer, you can probably crack most encryption. But for our purposes, I think it says a lot as lawyers if, even the CIA that is attempting to gain access still has trouble gaining access when documents are encrypted. And a couple of applications that do this encryption from end to end, where it got particular notoriety. First of all, is WhatsApp, which is used. WhatsApp is owned by Facebook, but WhatsApp does end-to-end encryption. Signal, which we've read a lot about, probably in connection with leaks coming out of the White House over the last few months. That's what they were saying a lot of members in the press office were using. But one that we probably use even more than either one of those two is Apple's messaging app has end-to-end encryption. And what's good about end-to-end encryption, or just encryption in general, is that by and large, for the purposes of us as lawyers trying to protect client documents and information that is encrypted is, I think we would be safe to, or we would be okay in saying today it is safe under any kind of ethical obligation that we as lawyers have. Unless you use some very, very old and very, very weak form of encryption, which gets more and more difficult as new apps are released that have the latest versions. So the point is that if you're going to use the cloud to store client documents or transmit client information, encryption is not a requirement under any ethical rule that I have seen. But 5 years from now, where are we going to be? I almost think that encryption may be in some way, shape, or form a requirement. And the reason is because it works. So there are a couple of ways to think through the encryption issue with respect to cloud data. And by and large, there are so many different kind of ways to talk about it. But one reason I'm focused on using using cloud storage is that I think in our day-to-day practice, that's more likely than not how we are using the cloud. And it's where our clients' documents, if they're going to be stored in the cloud, is where our clients' documents of other services would more than likely be stored. And so a couple of questions to ask or just think about is, so there are many, many different ways to protect data that's stored on a cloud server. So one is, when I send a document to Dropbox, for example, you can look at, there are multiple levels or multiple stages to the question of encryption. The first is, when I take a Word file from my desktop, save it to Dropbox, it has to be uploaded to Dropbox. As it changes, it gets synced back to my computer and any other device I have. So the question is the information as it is being sent to and from Dropbox encrypted? Is it encrypted at rest when it's just sitting there and no one is accessing it? Those are two separate types of encryption. They're two separate issues. One of the main concerns with the at-rest encryption is, can the employees of the company access that data? Because if it's encrypted at rest in some way, shape, or form, such that they cannot access the data, that's even safer. If it's encrypted in transit, then if someone were to intercept your upload or download, they would get an encrypted file. Chances are they couldn't open it, but the company, when someone serves a subpoena on Dropbox or serves some kind of document request on Dropbox, if their employees can get it, one, they can produce it without any sort of input from you if so required. But more importantly, their employees who don't have maybe the best of intentions can use, again, your client's information in any way they want to. So another way to think about this is, can you encrypt the data on your computer and send it and store it to the cloud, and then or send it to your client, and when it's re-downloaded, you unencrypt it? You can. I think that you, to some degree, need to do that for certain types of documents. I don't believe, and again, this is not necessarily my thinking on the issue in terms of what should be, but also what I believe is required under the current ethical environment or the current ethical rules. Certain categories of documents I think you probably do need to have encrypted if they are going to be sent, and I'll get to it, but I think that the run-of-the-mill document that you have probably does not need to be. The other issue is, again, how strong is your password? The reason I thought this was really interesting is because if your password is weak and the data is not encrypted, like isn't sitting on or like sitting in the storage system encrypted such that you have to unencrypt it before you can use it, all it takes is your password. I mean, and we saw, I think it was 2 days in a row that the press secretary posted what looked like a password to his Twitter account. Whether that was his Twitter account or like his Twitter password or some other password, the point is, and they look to be relatively strong passwords, but if your password becomes jeopardized, then most of this is for naught. So when I was saying that some documents may need to be encrypted or somehow protected, I think medical documents, if there is one category, medical documents are that category. And the reason is because, like the ABA's rules said, there may be other legal requirements over and beyond what you have as a duty as a lawyer. And these requirements are, obviously provided in the National Act, but Texas House Bill 300 has made those apply to law firms and lawyers as well. Lawyers and law firms have gotten fined, and the fines can be very, very, very high. One easy way, well, not easy way of dealing with this is when you're sending documents to opposing counsel or to other medical providers or whomever, to use whichever app you want to, but oftentimes you're sending PDFs. PDF has, or Adobe Acrobat has, built into it the ability to password protect and encrypt a file. WinZip and some other like zipping programs have the ability to encrypt zip files. Just use it. I don't think there's any harm in doing that, and I think it's probably what you're supposed to do in Texas. So a couple of questions that the New Hampshire Bar put out regarding using a cloud computing service. And these are the questions that you probably don't think about these same questions or think about the questions in the same way as you would with the copy service, but to some degree, if you knew your copy service let anyone off the street just go in and use their copiers and they could jump in while they were doing copies for you, you'd probably be a little bit concerned about that. Likewise, you want to take a look at what the security measures are that exist for cloud computing provider that you're looking at. The good thing, though, is that the majority of these questions, I think, are answered with respect to, again, lawyers performing their duty in protecting their clients' information. I think the majority of these questions are answered positively if you use a reputable cloud storage vendor and this is kind of the big one, I think, you pay for the service. There's just less incentive for companies to provide free services that provide the same protections that paid services provide, because the majority of people using free services don't really care that much about it. Whether they should or not is a separate issue, but they don't. And so just a couple of, some more questions, like in-house questions to think about is when you are allowing or disallowing services to be installed on computers at the office. So I know some companies, for example, do not allow USB drives or jump drives to download information from laptops. They've shut that down. Most law firms don't have that. And in fact, most law firms probably shouldn't have that from the standpoint of the flexibility that sometimes it requires to be a lawyer. I know that when I'm in trial or a hearing, I may need to download something quickly to give it to a judge or opposing counsel, whatever. But the point is, I don't think that lawyers and law firms think holistically about their security systems in the same way that companies do, in part because I think companies think more directly about the competitive nature of their information, whereas the identity of our clients, et cetera, is not necessarily the basis of what we think other people want from us. And so I think having someone in-house, to the extent that it's a large enough organization, it's really hard if it's a solo practitioner or an office with a few lawyers to have some outside IT professional who's like that's their only job is to work for your firm. And that's why I think having some understanding about how using the technology is important or potentially dangerous is necessary just for navigating this. And with respect to, again, using these third-party vendors, after you decide what your security policy is, you want to look a little bit more closely about why am I using this vendor instead of that vendor, this company instead of that company. With respect to actual devices, and this, again, the reason I think devices are just as important in a discussion about cloud computing is because the device is how you access the cloud, and so everything is for naught if someone can use your phone, if someone can easily hack your password, if you lose a device and don't tell anyone, etc. You can use encrypted hard drives so that if the hard drive is taken out of the computer and installed on another computer, it can't be read without it being de-encrypted. Same thing with flash drives. Wi-Fi, again, why? It's because when you use these services to access the cloud or anything else, if you're using if your Wi-Fi doesn't require a password, so anyone can log in on it, that means oftentimes you're going to be connected to a network of all the other people who are already on that Wi-Fi system. Sometimes people actually set up fake Wi-Fis in coffee shops, airports, etc., apartment buildings if you live in New York and there are enough people around you, to actually steal information from computers or from you when you log into that network. And so VPN is a good approach to that. So just a couple of the other storage concerns is that when you're companies that are companies that have obligations under the statute are not supposed to divulge the information that's stored short of a request from the government. But sometimes the government wants that too. And like we saw, and this was a few years ago, the government tried to get data stored on Microsoft's servers in Ireland, cloud data stored on Microsoft servers in Ireland, where a very large percentage of their data was. And the district court actually allowed them to do so. Search more. The district court initially, I believe, allowed them to do so. The Second Circuit, Microsoft believed so strongly that they shouldn't be required to do this, that there was an extraterritorial jurisdiction to access this information, that they actually were in contempt of court when they did this appeal. Fortunately for them, they won. And so the Second Circuit said that the government was not allowed to get the data. These sorts of stories, I bring them out not only just so you know about people trying to get data from that be stored in the cloud. More importantly, though, I think when you see how companies react to data breaches or requests for your information, that should, to some degree, also inform which companies you trust with storing your client's data. Can you really trust Yahoo after you know that they've had 2 breaches that they didn't disclose? They didn't even disclose it to the company that was buying them during the due diligence process. If they won't disclose that, how can you trust them with your data? Again, encryption. Zero knowledge is a very specific type of encryption. It's not very common. There are certain providers that provide or that have it. Essentially, it's the provider doesn't know what's stored on its own servers, and it can get so strong that the provider can't even give you your allow you to reset your password so you can get what's stored on their server. So if it's something that is that valuable and you have the ability to make sure you don't lose 2 passwords, it's something to consider. And I'll just skip, since we're getting close to the end. One thing to look for, though, when you are using cloud storage, if you're going to be using cloud storage to store medical records, some providers actually have a HIPAA certification. For example, Box.com, which is great. And so just if you want a turnkey provider that has some of these features, if they have the HIPAA certification, you can probably be certain that you trust them with all of this data that we've been talking about. Like I was saying, Box Cryptor and SpiderOak, if you forget your password, sometimes it gets shut down, so you also have to protect your client's data by making sure you still have access to it and will have access to it, even if the server goes down. So you want to know the reputability of the company, which goes to who else do they attempt to market to for their services. If you're talking about providers like Mega Upload and Rapid Share, they were marketing primarily to individuals who were sharing movies and video games and pornographic material. Well, even if they had great security such that other people couldn't access your client's information, it's probably not the best place to store it, because you know that their ability to stay in business is at risk if they are doing primarily illegal things. So I'll just skip to the end. I thought there was one more, but fair enough. Oh, there we go. So these were suggestions from a law professor. Again, some of these I think are more, like these are professorial suggestions. I mean, the Cloud Storage Vendor Service Agreement would be a great thing to read. But again, I think if you are using reputable vendors, and that includes Dropbox, it probably includes Gmail. And the reason I think it probably includes those is that they have so much of the market now and so many people use them. I just don't see it coming, certainly without warning, that all of a sudden lawyers can't use Gmail, lawyers can't use Dropbox. Whether you should is a separate question. Are there any questions?
How do you know whether your provider has encryption at rest so his employees can't get into it?
So that is one reason to read and do diligence on the provider. Oftentimes, I know, for example, with Dropbox, a few years ago, the free service did not have encryption, and the paid service did. That was one of the things that they were saying that you were paying for. It really depends on the provider, but that is usually something that the provider would make available or would say in their security section. Most of these providers have security white papers or just security discussions about how they protect client information.
And one other question: if you're using fingerprint on your phone, and somebody gets access to the phone, can't use the fingerprint, but somehow figures out your code, do they still get access to the banks and stuff that use fingerprint?
No. The bank is it would use the same fingerprint. Okay. Yeah.
So they couldn't, if they got your access code, access your fingerprints with the bank.
No. And one thing I did want to mention too, and was just in terms of this difference between free and paid services. Someone mentioned, or someone said, like there's a lot of discussion right now about how Google would show ads where ad companies or companies didn't want their ads to be shown. So let's say you had a huge opposition to the use of guns, and your company didn't want to advertise, for a YouTube video that was about target practice, for example. Google made it virtually impossible, and for a long time rejected these companies' attempts to limit where their ads would be shown. So they've started pulling their ads from Google. And this is what it took for Google to change its policies. And as someone said, if you're not paying for a service, then you're not the customer, you're not the client, you're what's being sold. And so so Google's customers are the folks buying ads on Google. Google's customers are not those of us using Gmail for free. So that's just one thing to keep in mind. And so if you're not the customer, you can't expect the same protections that a customer would get because you don't have the same pull with the company. You have a question?
Along that line, if we use Google, Yahoo, or even AOL now,
Yep.
and it's a free service, do we have a reasonable expectation of privacy?
I think to some degree, it depends on which particular service you're thinking about. And I think it gets a little bit, so I'm not quite ready, because I don't think that there is an actual, an opinion on this. And so we're trying to feel our way into what should be. And so I don't think I am quite comfortable saying you cannot use AOL or Yahoo or Gmail. And the reason is that I'm not entirely sure that the services that are better are quite as easy to use. And the reason I say that is because there is some kind of barrier to entry. But I am concerned about us moving too fast, and so exposing a lot of attorneys to like issues of not following their obligations under the disciplinary rules. But I think if you have concerns about the safety of your data, and you are using a service for free, then you would be well advised to do some research into it and more than likely move to something that's a little bit more secure.
But for example, if you have clients and clients use Gmail,
Mm-hmm.
and then you communicate, you transmit information which is confidential,
Sure.
but using a free service.
Right.
And the question is, will Google or Yahoo provide that expectation of privacy if somebody not coming in, not because of you as an attorney? What happens if they're coming in through the client?
Sure. I think if it's the sort of information that is, so the good thing is that all of the information that we're trying to protect is the client's information. You know, even attorney-client the attorney-client privilege is the client's and not the attorney's. And so I think if it is something, though, that you as an attorney are concerned about, I think raising that with your client is certainly worthwhile. And there are entire practice groups at law firms that are set up to advise clients on cybersecurity issues. That probably wouldn't apply to sort of an individual client who's using Yahoo or AOL, but if you believe that the communications are such that the client should be concerned about the expectation of privacy, I think you can raise that with them. Certainly, you may have an obligation to do so, but also keep in mind the client's confidential information is the client's confidential information. If they want to, post their bank account statement on Facebook, that's totally that's totally their decision. You just don't want to be the one that allows someone else to post their bank account statement on Facebook.
When I was in private practice, I always put that in my engagement letter that, either I'd have a policy that we don't accept emails, or if you do, that you advise them and educate them, because a lot of people don't think about it, they hit the button and go.
Yep.
Right? But that it's not a secure way of communicating, and that you need to be apprised if that's how you want to communicate with us, that it's not secure, we cannot be protected.
Right.
Because of the client.
Right. I think that makes a lot of sense.
In the old days, there might be 4 or 5 servers that your email would go through. Is that still the case, or is it more server to server now?
No, I think you're going to your emails and data are going to be all over the place. That's why I mentioned Amazon. So Amazon has a service. We think of Amazon as a place to buy diapers and books, and that's how consumers use Amazon. But the majority of companies that have any kind of internet presence use Amazon's data storage and web access, including Apple. So, Apple's iTunes is down, or like Apple Music is down, it may be because Amazon's web storage is down. Dropbox is down, it may be because Amazon is down. So you may be communicating with Dropbox is communicating with Amazon may be communicating with someone else. It's just the data is very it's everywhere, and that's one reason that I think the more and more encryption that is used, the more and more likely you are to protect the information, because it doesn't matter how many places it goes. If it's encrypted at all times, it can go to every server on on Earth, and it still would be encrypted.
What about Microsoft? Are they not a secure cloud service?
No. I think Microsoft is great too. So Microsoft has 2 different products. They have OneDrive and OneDrive for Business. OneDrive for Business is more than likely HIPAA compliant. And when I say more than likely, I know that I think they even advertise it as such. They also have SharePoint and using like Microsoft's email servers. And the reason, again, I think of it in terms of, as an attorney, if you are using a service that companies that have an interest in protecting their data use, I think that's another good question to ask yourself, and a good criterion to use. And the truth is that so many companies are using Microsoft's Office 365 for their email and storage that I would be very surprised that what is, to put it one way, what is good enough for IBM is not good enough for us.
They do have a HIPAA compliance certificate.
Yep.
At least the SharePoint does.
Exactly. So that may be the next step after OneDrive for Business. I think SharePoint is something that comes in with certain enterprise plans under Office 365. But the security for OneDrive for Business and SharePoint are probably close enough that even though it doesn't have the HIPAA certificate, it probably has the protections necessary under HIPAA. But
It's not expensive either.
yeah, something to keep in mind.
What about what used to be called Iron Mountain? I've forgotten their new name.
I'm not. I know them as the company that shreds paper.
Yeah.
They also do data storage.
Okay. Yeah, I'm not super familiar with them.
They were one of the originals, and I've been using them for about 20 years.
Well, I think, it's again, I think if it's something that businesses use to protect their information, that would be a good way to look at it.
As an aside to that, I was at a conference several years ago, and I used to represent medical providers, and one of the things that they wanted to do was to get into that market, and so they wanted to start storing their data. They refused to sign business associate agreements, though.
Interesting.
Very odd.
And one last question, VPN. How do you access that?
Well, you have to have the VPN server, set up, so there are multiple ways to look at it. One, you can sign up for like your own personal account with VPN, which is a very interesting, I think, a good thing to look at if you need any kind of anonymity, and if you do sign up, it's like free VPN is one. There are a bunch of free providers, but essentially just hides. One, it hides your location, so your IP address, but it also will provide some kind of, or like some level of encryption of the transmission. One thing to keep in mind though about VPN is that a lot of these services that are used like for anonymity are also located overseas, so you may gain and may lose at the same time.
So is Xfinity Wi-Fi, that's an open network too?
If you have to use a password to log in, it wouldn't be an open network. But there are some Wi-Fi systems, and some companies are adding Wi-Fi to their routers that you as a consumer would need to turn off, or else other people can get on the router. And they say that they have security in place, that they don't, that the data doesn't overlap, but who knows. Cool. Well, thank y'all very much. Yeah.
And that's all there is to it. For more learning opportunities like this, including online tutorials and in-person training sessions, visit the Harris County Law Library's Legal Tech Institute website at www.harriscountylawlibrary.org/tech.